Good evening and welcome to my weekly YouTube channel, The Abuse of Power, State and Legal. And please read the disclosure inserted at the beginning of this episode. This is episode 8. It's coming to you live from Limerick on Friday, the 29th of August 2025. It's in proceedings in connection with AIB loan 11876-020. Today we're dealing with the 6th day of October 2023, and previously on the 14th day of July 2023, Judge Colin Daly in Limerick Circuit Civil Court signed an order of possession against the property linked to this loan, and he put a 4-month stay on proceedings. I appealed the matter to the High Court, but the High Court hearing was going to be about a year. So the danger is that the stay on the order would have expired. So I made an application to the Limerick Circuit Civil Court, and it was Judge Colin Daly again who appeared on the 6th day of October 23. In the intervening period between 14th of July and 6th of October, I had made an allegation of misconduct against Colin Daly for his behaviour at the repossession hearing. When Colin Daly came into the courtroom and seeing me, he said that I want to object to him hearing this application of these proceedings. I said no, I had no objection. He said, what's it to do with today? I said, I'm looking for an order extending the 4-month stay on the order of possession. He said, how long do you want the order for? I said, I want it to coincide with how long do you want the stay for? I said, I want it to coincide with the High Court hearing. And he said, what are your grounds for the hearing? I said, well, my grounds were the fact that I was appealing your decision to the High Court. That was the sole grounds. He said, no, I want to know the individual grounds. I didn't like saying to Judge Daly it was his behaviour. It was the fact that only one side was heard. I had no advance notice of the proceedings. I had no witnesses. I had no affidavit evidence. I had no sight of the pleadings. I didn't like reminding him of his behaviour in court. So Judge Colin Daly said to me, he said, you're looking for an indefinite stay. I said, no. I said, an indefinite stay could mean anything. I said, I wanted just up until the day of the hearing. Judge Daly refused. He said, I don't want to prejudice the bank, and he refused to extend the stay of 4 months up until the day of the hearing. So that was pretty much the end of that application. As it transpired, that application was made under Order 61, Rule 6, an application to the Circuit Court. I didn't actually need to make the application. The reason being, you only make an application to the judge of the Circuit Court if a stay hadn't been granted in the first instance, but Judge Colin Daly had granted a stay of 4 months. Because a stay was granted, then on appeal to the High Court, it's the High Court judge automatically has jurisdiction to extend the appeal. But I didn't know this, and neither did Judge Colin Daly. When the matter appeared at call over in the High Court judge simply extended the stay on the order to coincide with the hearing date and simultaneously set the hearing date. So Colin Daly basically, I'm a layperson, I didn't know the court rules, but neither did Judge Colin Daly. And his refusal was to extend the stay period. It proved worthless. But that was the end of the hearing. So, right, where does this leave us? I just want to give a quick summary of my appearances before Judge Colin Daly. And I'll link it up a little bit at the end. On the 11th of February 2022, Colin Daly fixed a hearing date for 6 weeks' time with 3 AIB witnesses in attendance, and he said to me he should have summoned us straight away. On the 25th of March, in 6 weeks' time, the court was cancelled that day, and in the intervening period, Joint Crawford Law Firm and Lisa Finucane had made an application on foot of an alleged untruthful sworn affidavit to dismiss the witness summons. That application was heard in my absence on the 2nd of June 2022. Judge Daly dismissed the witness summons that he gave me leave to issue in accordance with court rules. In my absence, the reason it was in my absence is that somebody in the court office, whether by accident or on purpose, sent my notice of that hearing to a wrong address. It took a staggering 17 months to get Judge Colin Daly back into court to make him aware of what had happened. When I made Judge Colin Daly aware of what had happened, Judge Colin Daly responded. He said, you seem to have a good memory. I prompted him about saying issue summonses straight away. He checked he checked with the clerk, asked the clerk to check the diary when was the available date for hearing for witnesses lasting half a day. She said 6 weeks' time, 25th of March. Colin Daly said, was 6 weeks' time enough time to issue the witness summonses? We then discussed court rules. Witness had to be given reasonable time. Colin Daly said he should have summoned it straight away. And Joint and Crawford then filed, Anita Finucane and Joint and Crawford law firm and a solicitor in that law firm filed an untruthful affidavit saying that Judge Daly gave a different direction, which he didn't. Judge Daly dismissed the review of that witness summons on the grounds that there was only 14 days to hear that application. That application had to be heard in the High Court. But Judge Colin Daly made no effort. You know, he would have had discretion. He made no effort to determine the truthfulness of the affidavit. Right, on the 14th of July. On the 14th of July, Colin Daly, after lunch, signed an order of possession against the property, my property, which this loan was attached to. The order of possession, I had no advance notice of that hearing. I had no witnesses in attendance. I had no opportunity to file a replying to affidavit, and I had no sight of the booklet of pleadings that was used against me. Colin Daly ploughed on. He signed the order of possession anyway. He raises questions: was I subject to an abuse of procedure, process, state power? In many instances. When I complained Judge Colin Daly to the Judicial Council under Section 53, subsection 3, had no power to examine the actions of Judge Colin Daly. They had no power whatsoever on the grounds that the remedy was available if I pursued the matters to the High Court. I did pursue the matters to the High Court, and Colin Daly's orders were subsequently quashed. The difficulty this creates is that Colin Daly's actions haven't been investigated, the order has been quashed, and no one has examined the actions of Judge Colin Daly. I think, and also Petitioner Ryan, the President of the Circuit Court, has no authority or jurisdiction whatsoever. As of today, in August 2025, Colin Daly is now appearing in newspaper reports such as the Limerick Post or Limerick Leader Live Online. Colin is signing court orders. He's moved from the civil to the criminal courts. Whether it's temporary or permanent, I don't know. But he's appearing in the Limerick Post newspaper signing court orders in the criminal courts. And my issue with him is, you know, Colin Daly came face to face with the criminal act of perjury in the civil courts. Did Colin Daly realise the criminal act of perjury had taken place? The answer to that question is unknown. It's a definite possibility he did, but to evidence what a judge realised or ought to have realised is practically difficult. Is practically impossible. The only thing that an authority could do is examine what was the function of Judge Colin Daly on the day. When Colin Daly was made aware of an allegation of perjury, and when he was stepped through all the relative steps in the sworn affidavit, you know, Colin Daly made no effort to investigate his own diary and his handwritten notes. He made no effort to check court records. He didn't take into consideration that the plaintiffs weren't refuting what I was said or what I was saying. The plaintiffs put up no argument to it. So the only thing that an authority could do was what was the function of the judge, and also to cross-reference that with the actions of Judge Daly, what he actually did. Right, that's really it. Colin Daly's appointment. Colin Daly was appointed in 2012 by the Fine Gael Labour coalition government. Alan Shatter was Justice Minister at the time as a district court judge. Colin Daly was later elevated from a district to a circuit court judge. Again, Fine Gael also held the Minister for the Justice Department. The Minister for Justice was Helen McEntee. So his nomination, his appointment, and his elevation were both at a time that Fine Gael held the Justice Minister. And also Mara Whelan was the Attorney General at the time. Just come across a little bit of data there. In 2012, Alan Shatter, the Fine Gael Justice Minister, he appointed 17 nominations in total to serve as judges. He appointed 8 judges to the district court, Out of those 8 judges, 4 judges had known connections to the Fine Gael party or were Fine Gael party members. Colin Daly wasn't one of those 4. That's not to say he's not. He doesn't have political influence. Now, there's a book I've come across here. It's Jennifer Carroll McNeil, the current Fine Gael TD, and she wrote a book. It's The Politics of Judicial Selection in Ireland. I just want to quote a little paragraph of text here. The networking effect of being known. This is on page 145. One of the most important elements of the judicial selection process in Ireland in both periods is simply being known to the relevant decision makers. The next piece is Colin Daly was appointed in 2012 to the District Court. And for the vacancy of the District Court judge, Colin Daly was picked out of 90 CVs. So, Colin Daly must be either a very exceptional candidate and very talented individual if he's number 1 out of 90 CVs, or else the other option is that he's known to the decision makers. When he dismissed the review of my witness summons application, Colin Daly didn't know basic court rules. He had to ask counsel for the plaintiffs how long did I have to appeal his decision dismissing my summons. Counsel responded it was 14 days. He didn't know the rule himself. Colin Daly also stated at that hearing, he said the court may have erred in allowing an issuance of a witness summons by the defendant. That again was incorrect. It was false, because I operated perfectly within court rules. And then in October 2023, when I looked for an extension for the 4-month stay order, Colin Daly refused that stay order. Now, I'm a layperson, I didn't know that rule, but neither did Colin Daly. That application didn't need to be made at circuit court level. It was the High Court judge with jurisdiction, not Colin Daly at circuit courts. So that's 3 basic rules he didn't know. So, that's not supporting that he's the head candidate out of 90 candidates. And the 90 candidates per district court applicant, that's also coming from Jennifer Carroll McNeil's book, The Politics of Judicial Selection, when she's getting her facts from the Judicial Advisory Appointments Board reports. So 90 CVs, and Colin Daly was picked out of 90 by Alan Shatter. Now, Jennifer Carroll McNeil also interviewed Alan Shatter, and I just want to reference page 241, and this is Alan Shatter speaking. He said, I would religiously read all the CVs that came through of the recommended person. And as a former practicing lawyer, I was of some degree of insight into some of the applicants. So when Alan Shatter chose Colin Daly's CV, he personally read it. I would religiously read all the CVs that came through of the recommended persons for judicial office. So Alan Shatter was the Justice Minister at the time of Judge Colin Daly's appointment, and in an interview on the 25th of June 2015 to Jennifer Carroll McNeil, the current Fine Gael TD, he said he would religiously read all CVs of applicants. Now, Colin Daly was a successful applicant in that process, so Alan Shatter had to read his CV. So I hope, by the way, I'm not scandalising Colin Daly's appointment either. I hope this sequence of videos maybe one day might find its way to Alan Shatter, and he can see, with the benefit of hindsight, how Colin Daly is carrying out his duties on the bench, and to see what Alan Shatter thinks of that. But anyway, that's the end of this week's episode. Oh God, we've gone on for 14 minutes. Next week we'll be dealing with my High Court appeal. And thanks very much for listening. And if you like the content, please give it a thumbs up, and also consider hitting the subscribe button. And thanks everybody very much for watching.